Hello everyone. In this video we are going to discuss one of the important concepts, that is the land reforms after independence. Here the reforms are made after the independence. After the independence, the new measures taken up by the country, such as annexing certain independent state or such other territories with the Union of India, abolition of earlier existing intermediary systems, etc., have brought many changes in Indian land laws. Here the land reforms or the land laws after the independence can broadly be classified as the agrarian reforms, industrial reforms, social and economic reforms. Here the social and economic reforms is also known as the constitutional provisions or constitutional protections. Here next is legal, judicial and administrative reforms. So let's start with the agrarian reforms. But after the Indian independence, the 40% of area of land was controlled by the intermediaries like Jagirdars, Zamindars, Inams. The remaining 60% of land was covered by the Ratwari tenure. But with the large differences in ownership of land, the substantial portion of the land was cultivated through the tenants, who were paying 1.5 of the produce as the rent to the government. Besides, a large population of the country comprised of landless agricultural laborers. The independent India thought of securing the objectives of policy, conceiving land reforms and agrarian reforms, forming the part of economic reform by adopting the following proposed by the constitutional plans. They are the abolition of intermediary tenures. Here the intermediaries such as Zamindars, Jagirdars, Inamdar, these tenures were abolished. Second is regulating the tenancy system. Here the new laws were enacted for the purpose of including the fixation of rent, security to the tenant, bringing the tenant into the direct relationship with the state and investing the ownership in them. Third is the fixing of ceiling limit. Fixing the ceiling limit on the land holdings by the citizens for making available the surplus of land to be distributed among the landless agricultural workers and to use it for the public purpose. Next is the consolidation of agricultural holdings by increasing the size of the operational units, and next is the distribution of government or the surplus land among the landless poor persons, and providing the constitutional protections to the forest land and people living in the tribal areas, with a view to achieve the objectives under the Article 38 and the Article 39 of the Constitution of India to impose the ceilings on agricultural holdings, to distribute the surplus land to the landless poor person as a measure of social security. The second is industrial reforms. Since India is basically an agrarian country, the industrial growth and development is essential for achieving higher economic goals. Measures to the reform of the laws relating to land ceiling and to bring the new laws for compulsory acquisition and requisition of private lands. Similarly, the land laws relating to the protection of land from land grabbers, encroachers, etc. were brought into limelight, either by the way of new enactment or by amending the existing laws. One of the important measures was putting a ceiling limit on the urban lands, as well as the case of putting ceiling limit on the agricultural lands. The following are the important objectives of undertaking the land reforms in the form of urban land ceiling. The density of population in urban areas which is more than that of rural area. The land in urban area has been inadequate to meet the growing needs of urban areas. The duties imposed by the Article 38 and the Article 39 of Constitution of India, the state to strive for promoting for the welfare of people by securing and protecting social order in which socio-economic and justice is assured. There is a need for minimizing inequalities in incomes and eliminate the inequalities in status. The need for distributing the ownership and the control of material resources of the country at best to subserve the common good. In order to achieve the above goals, the Urban Land Ceiling and the Regulation Act was enacted in 1976. Over the years, the objective of enacting this law could not be achieved. Therefore, it was repealed in 1999 by the Urban Land Ceiling and Regulation Repeal Act. The another area of land reforms under the present head is the land acquisition and land requisition. The Land Acquisition Act of 1894 was enacted and it was in force even after the Indian independence, with a view of amendments made to it from the time to time as a central government until it was repealed by the present act. That is the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement 2013. The Land Requisition and Acquisition of Immovable Property. In 1952, Requisition and Acquisition Immovable Property Act 1952 was enacted by the central government with a view to provide for the requisitioning and acquisitioning of immovable property for the purpose of the Union. Socio-economic reforms, which is also known as constitutional protections. India being an agrarian country, majority of population is living on agriculture. Even after the independence, the attention was also turned to the industrial development, so the socio-economic reforms can be improved. The attention was given to the land reforms, but also to increase the standard of living of people. Here, the government at center and state has brought many changes in respective laws relating to land reforms, either by enacting new laws or by modifying the already existing ones in conformity with the constitutional goals of achieving socio-economic justice to the people, given under the Part 3 Fundamental Rights and Part 4 of Directive Principles of the State Policy under the Indian Constitution. The next is the legal reforms, judicial reforms and administrative reforms. The land reforms in context of legal reforms envisage either enacting new laws and policies or to modify the same to suit the present needs and the future aspirations. The judicial reforms include an interpretation of laws made by the parliament or the state legislatures in relation to the land laws prevailing in the country. The Indian judiciary has contributed valuably to the subject of land reform. The participation of state has become essential for upbringing the land reforms and updating the land laws. The number of amendments was also made by the constitutional provisions with special reference to the abolition of intermediaries, princely states and center-state relations, etc. Similarly, the government at the center and state have made many administrative reforms forming the part of land reforms by establishing the organized machinery to further enforce the objective of land laws and lay down the national policies in relation to the land reforms such as for forest policy and forest laws.